A few weeks ago at the Phoenix School of Law, I invited Judge David Campbell, who's the chair of the Civil Rules Advisory Committee, to address the students on the current state of the rules amendment process. And he outlined a proposal that had three elements. First, if a party failed to preserve information that reasonably should have been preserved for whatever reason, the court may order curative measures. These could include further discovery or some other procedural solution to put the parties back in the position they were in before the information was lost. Secondly, a court could not impose punitive sanctions or give an adverse inference instruction unless the failure to preserve was found to be willful or in bad faith. And third, that the court would consider the following factors when it's considering what is bad faith: the extent that the party was on notice, the reasonableness of their efforts to preserve, whether a specific request was received, whether the parties had engaged in any dialogue or negotiation, the party's sophistication, proportionality, whether timely guidance was sought from the court. Now, some of these factors directly implicate a party's information and records management system. Reasonableness of their efforts to preserve or their level of sophistication. Others indirectly, the extent to which the party was on notice, which is a function of internal communications, particularly in large multi-layered organizations. Proportionality, which is a function of the ability of the party to accurately estimate the volumes of ESI or its accessibility, the potential relevance of information sources, and to engage in a practical cost-benefit analysis. Judge Scheindlin, what do these factors really mean to records and information management professionals, the people in this room?
All right, I think you're asking me about the factors that a court should consider in deciding on these punitive sanctions. So let me first say, I have no problem with the advisory committee's current idea of separating what they call curative remedies, curative remedies as opposed to punitive sanctions, depending on state of mind. So if you act with a less culpable state of mind, in other words, negligence, or not even, and things are lost, we should try to make that up if we can. We should allow more discovery, maybe shift attorney's fees, whatever. That's fine. But as far as the punitive sanctions, the adverse inference or a case-ending sanction like a default judgment or the exclusion of certain evidence, that's a serious sanction, and here are these considerations. Well, what is the practical effect of this list of ideas on you folks? And I gave some thought to that, and I kind of need to go out of order. Specificity of notice has always been around. How are you on notice of this duty to preserve anyway? Did you get a letter from a preservation letter from an adversary? And you know, I think that those are a little overdone and over-encouraged because when somebody files a lawsuit, they ask for $1 million. Do they really mean $1 million? No, they'll probably settle for $25,000. So by the same token, just because somebody asks you to hold every record ever created, it's meaningless. It was just like the $1 million in a $20,000 lawsuit. Really, who cares what they ask for? You should do what's responsible. So, okay, it puts you on notice, but you don't have to do everything somebody writes to you in a letter.